This is Botsch versus Allstate Insurance Company, and this is scheduled at 10 o'clock, and we have both sides here for this, and each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes, if you desire. Just let me know. And we ask you to stand behind the podium and stay in place because we do video record everything that's put on YouTube. And then also, I don't think this is relevant here, but the moment I don't say it and I forget, then somebody will say something I'm not expecting. With victims and minors, we do not use their names. We use initials or just refer to them as the child or the victim. I'm trying to think if there's anything else. Yes, and the monitor over there, that will show your time. And I'll try to remind you if you're getting close to, the end of your, your time that you've reserved for rebuttal or whatever. But other than that, I think we're ready to proceed. If you two are ready to proceed. Okay. All right. Thank you. We've read your briefs. And go ahead.
Good morning, Your Honors. Attorney Eric Hall here on behalf of the appellants John and Raymond Botsch. I'd like to reserve 5 minutes for rebuttal, if I may.
That would be fine.
Thank you, Your Honors. This case began was back in November of 2020. Raymond Botsch was the owner of a large boat. It's a 30-foot well-craft boat, and I guess you'd describe it as a cigar boat, a racing boat with a trailer. This boat is his brother's house parked there, which is John Botsch. There's a homeowner's insurance policy. That policy is through appellee, which is Allstate. The appellant Raymond Botsch was in the process. Their mother had passed away, so that policy was in their mother's name. It was in the process of getting that policy, trying to get that policy into his name or his brother's name, and out of their mother's name, who was deceased at that point. On November 15th, there was a storm. It was a pretty strong storm, which basically blew a large pine tree down, uprooted it, blew it down, and that pine tree hit in the center, right across the center of the 30-foot well-craft boat, which basically almost split it in two and also crushed the trailer. Appellant Raymond Botsch made a claim for the loss of the boat, which is valued at around $250,000. That claim was denied by Allstate, indicating that it wasn't covered under the policy. The issue in this case were there was an individual, Matt Piat, who that was the person that Mr. Botsch, Raymond Botsch, was talking to about the policy that was under their mother's name and about what was covered. During that time, there was discussion about whether the personal property, and Mr. Raymond Botsch's personal property would be everything except the home and the land. He believed that the boat was covered under that policy. At no point in time was he ever told that that boat was not covered. Later determined that Matt Piat was not a licensed insurance agent. He was considered a sales producer. But that was the person that appellant Raymond Botsch was working through. This lawsuit was filed. It was filed originally in the Medina County Court of Common Pleas. Appellees removed it to the district court. At some point in time, there was a motion filed by appellants to remand the case back to the common pleas court because the amended complaint, or second amended complaint, added a party, an individual, Matt Piat, that defeated diversity, and then the district court remanded the case back to the Medina County Common Pleas Court, which the matter came up before summary judgment. The court granted summary judgment indicating that there was no genuine issue of material fact as far as whether the claims breach contract, bad faith dealing, and fraud. I believe the trial court erred in this case because although the policy itself indicates that that particular type of boat is not covered, the conversations that appellant Raymond Botsch had with this, I call him an agent, but he's considered a sales producer, but that was the only person that Mr. Botsch was talking to about the policy indicated to him, and this was in his deposition testimony, it was at transcript 23 to 33, that the policy would cover all personal property. All personal property would have included the boat, boat's personal property. The only thing that's not personal property is real property, which is the home, and the land that the home's on. Had he known that that boat was not covered, he would have obviously gotten insurance on it. The law in this case is, where provisions of contract and insurance are reasonably susceptible to one or more interpretation, they will be strictly construed against the insurer and literally in favor of the insured. Mr. Botsch, Appellant Ray Botsch, is not an expert on insurance. He relied on the representations of Matt Piat, who was the cultural sales producer, but he was the person in the office that was the only person he was talking to. He talked to anybody else at Allstate, after the Allstate, about to know their agents.
Counsel, whenever the representation was made that all personal property was covered, was there a particular discussion in regard to a boat?
No, Your Honor, and that's what's interesting in this case, is that if you're an insurance agent, you would want to know, I think from two standpoints. From one, to make sure that the insurance is properly covered, and also from a business standpoint, that if there's property that could not be covered in the policy, you certainly would want to discuss that from a business standpoint, because if there's additional insurance in your policy need or changes, that would generate more sales or income for the agent and for the insurance company. If there's things that can't be, collections of paintings, other types of antiques, or other things that wouldn't be covered ordinarily on a homeowner's policy, you'd want to discuss that with the insured, because at that point you would tell them that that's not covered. Also, you could sell them into a more expensive policy that would actually cover those things. None of that was discussed. My understanding, based on the deposition of Matt Piat, is that after leaving the, the insurance field that he was in, he was working in construction. So I think he was somebody that really, well, obviously he wasn't a licensed agent. Athletes would concede to that. He was considered a person who sold insurance. The fact that, Raymond Botsch in his deposition indicated that he believed, based on the representation of Matt Piat, that all personal property was covered. I believe that's a jury issue. That's for the jury to determine whether that's credible, or whether Matt Piat would testify and say, I never made those representations, or he knew based on discussions that it wasn't covered. That's an issue of credibility. It's a factual dispute, and I believe the trial court erred in making a decision on what is considered a factual issue, and one that should have been presented to the jury for determination as far as credibility and what the facts actually were in this case. The vote itself at this time is still, I believe it's beyond repair. I don't think that type of vote can be repaired. I think it's the replacement price $250,000. So it remains, Mr. Botsch, Raymond Botsch, still has suffered the damages of the loss of that vote, Your Honors. Do you have any other questions?
Apparently not.
I still would like to reserve my 5 minutes.
Sure. Thank you.
May it please the court, counsel. My name is Margot Mule. I represent Allstate Vehicle and Property Insurance Company and Matt Piat. I wanted to start off with a couple clarifications relating to the facts. The policy at issue was a homeowner's policy that was originally issued to the Botsch brothers' mother. Raymond lived with the mother. About 15 to 20 years prior to her death, which occurred in 2017, their mother decided to transfer title to the property in Seville to her son John, who is also an appellant in this case, and her 2 daughters. So that happened around, again, 15 to 20 years before her death. The insurance policy was issued through an agency that would hold the actual licensure to sell insurance, and it was the John Braun Agency. In 2017, Mrs. Botsch passed away. Raymond Botsch, appellant Raymond Botsch, lived on the property. He did not have a titled interest in the property. Not that that's an issue before the court, but I wanted to clarify the facts there. Soon after Mrs. Botsch passed away, the Botsch brothers went to the Braun agency and they actually changed the name of the owner of the policy to John Botsch, since he was a titled owner of the property. There's no question, Your Honors, about certain facts in this case. The boat that we're talking about is a very large cigarette boat that was owned by appellant Raymond Botsch. Raymond Botsch actually had 2 boats on this property that had been his mother's property. And in fact, as the record before you shows, he actually had an insurance policy on one of his other boats. So it's clear that he knew that you needed a separate insurance policy for your boats. Nevertheless, the undisputed facts here are that Mr. Raymond Botsch owned the large Scarab cigarette boat and trailer, and that it was not in a fully enclosed structure or building as required by the policy. The policy itself indicates that there is an exclusion for any watercraft. Personal property is covered, but watercraft is not, unless it is in an enclosed structure, building. And even then, Your Honors, if the watercraft is in such a building, if there's a loss, there is a limit as to the amount that would be covered, and it's only $1,000. This case does not involve an interpretation of an insurance contract. It is rather based, what appears to be, on negligent procurement of insurance. And what I mean by that is that this case does not involve an ambiguous term in the policy. There's no question that this policy does not cover watercraft, and it makes sense. It's watercraft, especially of this size. Look at the claim that they're asking for. They're asking for $250,000 for this boat. So it's a very large risk. The evidence before you establishes that Matt Piet, who was authorized as a sales producer, that issue is not before the court about anything as far as licensure or anything of that nature. That was not argued in the trial court, not before you here today. Mr. Piet did work at the John Braun agency. He did speak with at least Raymond Botsch. There was no mention of this boat, ever. And in fact, Mr. Piet testified in his deposition that had the boat been mentioned, he would have indicated that they needed to go to a different agency because Allstate doesn't write policies for watercraft of that sort. So there's no question here about several of the points and issues that were before the trial court. One, the exclusion clearly applied and the claim was properly denied by Allstate. Second of all, there was a claim made by John Botsch. It was established at the lower court that John Botsch did not have a titled interest in the property at issue and therefore had no standing, if you will, to be a party to the case. Third aspect was the fraud component. There was absolutely no evidence before you as you conduct your de novo review of the record that there was any type of fraud involved, and in fact that was never even argued by the appellants at the trial court or before this court. Another aspect is the Matt Piet Insurance LLC was named as a party. The uncontested evidence at the trial court level was that that didn't even exist, so the trial court properly granted summary judgment as far as that party is concerned. The fifth issue, bad faith. That has not been argued today. There's no argument in either the summary judgment response brief or any of the briefing that is before this court about bad faith. So the claims against Allstate were properly granted as far as summary judgment, and Allstate is not actually a proper party to the case either, because the breach of contract claim was clearly and properly dismissed by the trial court. So that again leaves the negligent procurement claim with respect to Mr. Piet. And what I'd like to point out to the court is that in nowhere in the record is there any evidence before you that the appellants at any point spoke to Mr. Piet or anyone at the agency or at Allstate about getting insurance on a boat. And the law is clear that you are required to ask an insurance agent or sales producer for what it is that you want to insure. And in this particular case, again, the record is devoid of any evidence that there was any specific conversation about property of the type involved in regard to the appeal before you here today. Therefore, there can be no negligent procurement because there were no misrepresentations, there were no statements made. Nowhere in the record will you find that some conversation took place at the John Brunn agency relating to this particular scarab. In addition to that, the appellants had the obligation to review the terms of their insurance policy and know whether or not they had adequate coverage based on their own knowledge of their personal property. So having said that, Your Honors, and as is detailed in my brief before this court, I believe that the trial court properly granted summary judgment in favor of Allstate and Mr. Piet, and I believe that you should affirm that decision. Thank you.
Thank you, Your Honors. John Botsch was joined in this lawsuit because initially when filing the complaint, parties, we wanted to make sure that we had joined all necessary parties. So that's why, in that standing, as a term, you didn't have standing, but we want to make sure that all necessary parties were joined in the complaint. This is not an interpretation of a written policy. We're not disputing that. It's an interpretation of the four representations that were made. Matt Piet, whatever you want to call him, he was acting as an agent per se, not a licensed insurance agent. He had a license, but he's acting as an agent on behalf of the appellees, Allstate. Whatever you want to call him, a sales producer, but he's still an agent, acting in an agency. It's obvious that the actual vote, the scared vote, was not discussed because had it been discussed, it would have been insured in this case. The vote was discussed as personal property, which the scared vote is personal property. It's not any other type of property. The agent did not explain the coverage as far as personal property. Personal property could be everything. It could be the boat, it could be the clothes that you're wearing today. That's all personal property. He either didn't take the time to explain it, or he lacked the knowledge or experience to explain it. As a sales producer, this type of coverage to discuss in depth the type of coverage that somebody needs, or what they, as far as policy, the question to ask somebody if they want insurance, or to change their insurance policy, or to sign or to change the policy holder. These are all questions that should have been asked. They weren't asked. This was a breach of contract. The oral representations that all personal property would be covered altered the four corners of that written agreement. And the law says that any provision of the contract, and they can be altered by oral representations if they're susceptible to more than one interpretation. In this case, what is personal property is susceptible to more than one interpretation. Okay.
Well, what about the exclusion though of watercraft?
Oh, I'm sorry, Your Honor.
What about the policy have an exclusion of watercraft?
It didn't have an exclusion. Well, it didn't have an exclusion in total. There was a provision that if the watercraft was in a covered structure, that it was covered, but only to the extent of $1,000. That's in the written policy. It didn't discuss any type of, as far as all personal property. The Botches are lay people when it comes to insurance. Okay, they were relying on the John Brunn agency, who employed. There's no question that Matt Piet was an employee, quote unquote, employee agent of the agency. So there's some responsibility here. We believe the court erred in granting summary judgment on this. I think this is a jury issue to determine whether there's negligent procurement, whether the terms of the written contract, the four corners were altered by any representations. That's a factual dispute, and that should have been heard by the trial court in a trial. Thank you, Your Honors.
Thank you. Thank you both for your presentations to the court today. The court will take the matter under advisement and issue a written opinion, and that will be sent to both sides, and we also release on the Ohio Supreme Court website as well. Thank you.
Thanks.
Have a good day.
You too.